So on to Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So basically, the Constitution says that we can do these things, these 8 things listed above in the Bill of Rights, but those are by no means all the rights the people have. There are an unlimited number of rights. You have the right to walk down the street your house is on, wearing an ugly Christmas sweater. You have the right to eat um, chocolate fudge ice cream. You have the right to smoke a cigar in your home. You have anything. I mean, you could name 20 rights. I could name 20 rights. All of us could, and we'd be here through the summer. But that is Amendment 9 in a nutshell. So there is some dispute amongst constitutional scholars about what this amendment actually meant and its legal effect. There's consensus about where it came from. The historical fact is pretty much undisputed. So during the ratification, and you read this in your book, and we talked about this some earlier. So during the ratification debates over the Constitution, there were opponents of ratification, the Anti-Federalists, Party of Jefferson. They complained about the absence of a Bill of Rights. So in response, the Federalists, the supporters of the Constitution, like James Wilson, they argued that a Bill of Rights would be dangerous. Because if we enumerated any rights, enumerate meaning write them down, list them, he thought that everything that was not listed would be surrendered. So you can only do what's in Amendments 1 through 8. Okay, well, that doesn't say anything about my right to wear a necktie when I put on a suit, or that I can only buy suits made in Guatemala or whatever. I mean, there are all sorts of rights that you have that you don't necessarily think of as rights. Your right to pick out the clothes you want to wear, your right to shop at a store of your choosing, your right to buy groceries at Aldi's instead of Walmart, and anything. So if we were to have a Bill of Rights, this guy says, and this is a reasonable thought back then when they were founding a country, if we don't write down every single right that an American has, well, somebody in the future might say that we don't have the rights, like I discussed, to shop at Aldi's or to wear a necktie with a suit, because it's not written down. We surrendered those, but that's obviously not the case. So because it is impossible, and it really is truly impossible to enumerate all the rights we have as citizens of the United States, a Bill of Rights might actually be construed, be used in a way to justify the federal government's power to limit the liberties of the people that were not enumerated. And this is a big deal. I mean, can you go to a private school? Do you have to go to a public school? Should your inability to pay prevent you from getting medical care? Do you have a right to medical care? These are important questions. And the thinking was, if we wrote these things down, that you had X, Y, I mean, there was no conception of medical care. If you were sick back then, the doctor would come to your house and they'd put leeches on you and suck the blood out of your veins. It's a little dramatic, but I mean, they bleed you. So this was a problem. But because the Anti-Federalists' demand for a Bill of Rights really resonated with the public, Federalists like Madison countered with a pledge to offer amendments after the Constitution's ratification. So let's get this Constitution out of the way first, then we'll come back and put in a Bill of Rights. You have my word. And back then, somebody's word was good. So Madison said this. You could take it to the bank that it was going to happen. All right. So Madison came from Virginia. Madison was representative of that state to the first Congress. He repeatedly insisted, over people's indifference and people's very vocal opposition, that the House take up the issue of these amendments that we're studying. And he says in a very famous and much analyzed speech that unfortunately we won't have time to really get to, he introduces a list of amendments that he proposed be inserted within the text of the Constitution. So it's literally to amend or change it. Now, it is done that way. If we were in class, I'd do this on the board, but just bear with me. So what he's suggesting is, pretend this is the Constitution, right? I don't like this bit. Pretend that says something very, very intelligent and very worthy of, being in the Constitution. So we're going to X that out, and we're going to write this above it. Now, we obviously don't do it that way with the federal Constitution. The Illinois Constitution works that way. We insert amendments within. And by the by, I happen to be teaching, if you like me, if you like what I've done, I happen to be teaching state and local government in the fall, Political Science 119, Tuesday and Thursday, 1 to 2:15 p.m. Don't know the room, but you should sign up. So he proposed that there be prefixed to the Constitution a declaration that government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of life and liberty, with the right of acquiring and using property, and generally of pursuing and obtaining happiness and safety. So what is he kind of riffing off of? The Declaration. Right? Thomas Jefferson's great contribution. The Declaration of Independence. So he wanted that in front of the Constitution. So at the end of the list of rights that were to be added to Article 1, Section 9, Madison wanted to place this, and this is the forerunner of the Ninth Amendment. So the exceptions here or elsewhere in the Constitution made in favor of particular rights shall not be so construed as to diminish the just importance of other rights retained by the people. So just because we say in this Constitution that you can say what you want, that you can own a gun and use it to defend yourself against a tyrannical government, doesn't mean that you can't also farm land and plant on that farm whatever crops you desire, something like that. So, or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or as inserted merely for greater caution. So Madison proposes here that the provision that eventually became the 10th Amendment be inserted after Article 6 as a new Article 7. So this contains fragments of Amendment 10 as well. In his speech, he says the following: "It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration, and it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general, meaning federal government, and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into this system, but I conceive that may be guarded against." I'm reading it verbatim because it's that important. So he acknowledges the other side. He says, yeah, this is a very fair and valid point. Because remember, these guys just fought off the greatest empire the world had ever seen up until that point. It was entirely plausible that a president like Adams might have taken some of these rights unto himself, and said this is the purview of the federal government. It was entirely possible that we would have had another president after Adams. We've had presidents do this. Woodrow Wilson threw you in jail during World War I for reading the Constitution, reading the Bill of Rights on street corners. I mean, that doesn't strike me as a particularly constitutional act, but we've had leaders do this since. So it didn't have to be Adams. It didn't have to be Madison. It didn't have to be John Quincy Adams. I mean, we go all the way to now, Trump. And this is a very, very valid concern. That if we include a Bill of Rights, everything that isn't in that will be taken onto the federal government or the state government even. But he says it can be guarded against, and it can. So all of Madison's proposals here were then referred to a select committee, and these are still around today, of which he was made a member along with Roger Sherman. The committee dropped his proposed declaration and wrote the Ninth Amendment to read as it reads today. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So at the urging of Sherman, what eventually emerged from this House, from the House of Representatives, the People's House, was a list of amendments that was appended to the end of the Constitution rather than integrated within the text. So since the enactment of the Bill of Rights, there have been scholars, there have been judges, lots of people really have argued about what Amendment 9 actually means and the legal effect that it has. And the courts haven't really relied upon Amendment 9 for any sort of judicial interpretation. So during his failed confirmation hearing to become a Supreme Court Justice, Robert Bork, and if you don't know who Robert Bork is, here's Robert Bork with President Reagan. Being nominated to...
Don't like it when your man takes off his ring? Get him a groove ring.
Hey ladies, we need to have a talk.
Bye, Mom.
Have a good day.
Well, let me announce in advance that I am making a brief announcement here, and then the judge and I are going to depart. And I won't say to you no questions. I know better than that, having been in here before. There will be no answers. But it's with great pleasure and deep respect for his extraordinary abilities that I today announce my intention to nominate United States Court of Appeals Judge Robert H. Bork to be an Associate Justice of the Supreme Court. Judge Bork is recognized as a premier constitutional authority. His outstanding intellect and unrivaled scholarly credentials are reflected in his thoughtful examination of the broad, fundamental legal issues of our times. When confirmed by the Senate as an appellate judge in 1982, the American Bar Association gave him its highest rating, exceptionally well qualified. On the bench, he has been well prepared, even-handed, and open-minded. In taking this action today, I'm mindful of the importance of this nomination. The Supreme Court of the United States is the custodian of our Constitution. Justices of the Supreme Court must not only be jurists of the highest competence, they must be attentive to the specific rights guaranteed in our Constitution and the proper role of the courts in our democratic system. Judge Bork, widely regarded as the most prominent and intellectually powerful advocate of judicial restraint, shares my view that judges' personal preferences and values should not be part of their constitutional interpretations. The guiding principle of judicial restraint recognizes that under the Constitution, it is the exclusive province of the legislatures to enact laws and the role of the courts to interpret them. We're fortunate to be able to draw upon such an impressive legal mind, an experienced judge, and a man who already has devoted so much of his life to public service. He'll bring credit to the court and his colleagues, as well as to his country and the Constitution. Justice Lewis Powell, in announcing his retirement, said the court should not be hampered by operating at less than full strength. And with this in mind, I urge the Senate to expedite its consideration of Judge Bork, so the court will have 9 justices when its October term begins. And I have every expectation that it will do so. We are now going to depart.
Liberals say. Liberals.
You should be rushing for the phone saying, give me a...
Liberals say he'll roll back the clock.
Well, so much for no answers. But anyway, yeah, Robert Bork. So he analogized the Ninth Amendment here to an ink blot, which hit the constitutional text that was under it. So it's just as judges should not guess what was under an ink blot, he argued, so too they should not guess at the Ninth Amendment's meaning. So his very, very, very public denial that there was any meaning at all to the amendment could be discovered and fueled rigorous academic interest in the original meaning of the text. And then the literature that developed much of the controversy surrounding these comments concerned the original meaning of the phrase rights retained by the people. So since the 1980s, we've had 4 different interpretations of rights retained by the people. I'm not going to ask you about any of these names, so don't worry about who Russell Kaplan is or Thomas McAfee. So Kaplan says it refers to rights that were granted by state laws, which could be preempted by federal laws under the Supremacy Clause. Thomas McAfee contends that the amendment referred to residual rights that are not surrendered by the enumeration of powers. So if this is to be believed, it follows if Congress is exercising its enumerated powers, it cannot be violating a retained right, which makes a certain amount of sense. Akhil Amar says that its core meaning referred to the collective rights of the people, for example, to alter or abolish the government, and that the supposed protected counter-majoritarian individual rights was anachronistic, meaning old and outdated. So Barnett said that the amendment referred to the natural liberty rights of the people as individuals, which are also referred to in the Declaration of Independence, the State Bill of Rights, Madison's proposed addition to the preamble, which we talked about a few moments ago. So this interpretation, the Barnett, that was the only one that would have much application to the legal cases or controversies going forward. So other scholars have focused on the meaning of this constitutional law stuff. I mean, it gets really nitty-gritty. What's the meaning of the word "the"? In this particular phrase, type deep. So we focus on the phrase. Some of them shall not be construed to deny or disparage. So while you concede maybe that the rights retained by the people include the unalienable rights to which the Declaration of Independence refers, Justice Scalia argued that the Constitution's refusal to deny or disparage other rights is far removed from affirming any one of them, and even further removed from authorizing judges to identify what they might be and to enforce the judge's list against laws duly enacted by the people. So Justice Scalia just said that the amendment has no judicially enforced legal effect, because he says just because the Constitution doesn't deny other rights, well, that doesn't mean they say that you have them. And judges certainly shouldn't be identifying what these rights you may or may not have might be. And they shouldn't be enforcing maybe a judge's wish list against laws that are enacted by the people through the legislatures of the 50 states and in Congress. Certainly a perspective. So the federalism approach, advocated by Kurt Lash and Randy Barnett, again, I won't ask you about those names, would give the provision judicial effect by narrowly construing the scope of the enumerated powers of Congress, especially its implied powers under the necessary and proper clause. And if you've forgotten what that was, pick up the Constitution packet I gave you, or if you have a copy, go get it and look under Article 1. Barnett also says the Ninth Amendment mandates the equal protection of enumerated and unenumerated rights. So unenumerated rights should be protected to the same extent that enumerated rights are protected in courts. And to implement this requirement, he proposes a rule of construction called the presumption of liberty, to protect all the retained rights of the people by placing the onus, so placing the burden on the state legislatures or the federal Congress to justify their restrictions on the liberty of the people as both necessary and proper, without judges needing to specifically identify the retained individual rights. So leave the judge out of it. It's up to the Congress or the state legislatures to tell the people why they can't have this liberty anymore. The judges don't need to specifically be identifying individual retained rights. So Lewis Michael Seidman says, well, it defeats the inference that the enumeration of some rights denies the existence of others. The amendment doesn't establish the existence of these other rights. So as opponents of unenumerated rights cannot rely on the enumeration of some rights to defeat the claim that there are other rights, proponents of unenumerated rights cannot rely on the text of the Ninth Amendment to prove that the rights exist or to establish what the rights are. So the Ninth Amendment, in his view, just says, it leaves the argument about unenumerated rights unresolved, because the Ninth Amendment only says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. It doesn't tell you what they are. It doesn't tell you what they aren't are. So there is room for some legitimate debate on what these rights may or may not be. And that's all I got for you on Amendment 9. Thanks for listening.